Good morning. Are you Cody Dent?
Yes, ma'am.
And Mr. Dent is on probation in two cases, 13-17772 and 22-41052 for the offenses of obstruction or retaliation and theft of property. Those both have motion to revoke pending. And then there is a new allegation or new indictment in cause number 250807 of burglary of a building. And Mr. Samuel,
Yes, Your Honor, I've been hired to represent Mr. Dent. I went out and visited with him this past weekend, and I've also spoken with him this morning. And as a result of my evaluation and talking with him, I believe it's merited to have someone appointed to give a professional evaluation. We realize that he is on probation. I realize there is a new charge. This is our first setting. I've not had an opportunity to complete discovery, but I think upon getting the information from discovery, and if we can set for bond hearing at a later date, maybe next week if possible, we believe that the results of that evaluation will show that there's possibly some alternatives that are available.
so it's set for bond hearing today on those motions, but you want some time to get up to speed on that other case. You want me to put that off and just hold it?
Yes.
Okay.
Yes.
All right.
At least until next week. I'd like a quick turnaround because right now there is no bond.
Right.
And he needs to get assistance.
Okay. An evaluation won't happen in a week.
I understand.
Okay, so but you still think give you a week to get up to speed,
Correct.
bond hearing next week,
Correct.
and then I'll look at your motion for the evaluation. We'll take care of that.
And
Right.
I've talked with the prosecutor.
Okay. We'll reset it. How's next week? Are we?
Yes.
We're good? Okay. We'll reset it for 1 week for a bond hearing on those two motions.
Right.
Thank you.
Thank you, Your Honor.
Good morning. Are you Tracy Haynes? And this is cause number 240514. I'm going to take judicial notice of the court's file. Mr. Haynes was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I received a packet from them dated June 23rd of 2025 with that report from Dr. Samantha Guzman with the opinion that Mr. Haynes has achieved competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No.
Then at this time, I will find Mr. Haynes is competent to stand trial. And will he waive the formal reading of the indictment, Mr. Parker?
He will, Your Honor.
All right, Mr. Haynes, in cause number 240514, the state's elected to proceed on count 1 only. It alleges you committed the third-degree felony offense of obstruction or retaliation from February 3rd of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
The stuff on the computer.
The stuff on that computer tablet, did you go over that before you signed it with Mr. Parker?
Yes.
And do you understand those documents that you signed? Speak up, please.
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? So if I follow your agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone. Speak up, please. When you're answering, I need you to speak up. And sentence you in accordance with your agreement to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Good morning, sir. Are you Jack Hooper?
Yes, Your Honor.
And in cause number 17-27896, Mr. Hooper is on probation for driving while intoxicated, third or more. There was a motion to revoke filed. We were previously here. Entered pleas of true to counts 1 through 6. I've received an updated pre-sentence report, and the agreement was for a cap of 4 years. Is that correct?
That's correct, Judge. He's indicated to the probation officer, indicated to me that he would rather not be put back on probation. He's asking to be sentenced to 3 years. He doesn't have, he doesn't have any new cases as violations or the possession, testing positive. He seemed to report to the probation department and did everything he did. The problem was he had an issue with marijuana. We're asking that, I think he should be given some consideration for that. We're asking for a 3-year sentence.
So you stopped reporting back May 5th of 2021. So didn't really report as
I apologize.
directed.
I spoke that.
You've been an absconder since 2021. Ms. Malfino?
Judge, I think the consideration that he was given was with the cap of 4 years. I completely understand if based on the original PSI and his history and his attitude, the court does not think that that is an appropriate amount. But I would obviously recommend revocation, whatever amount you think is appropriate if we need to revisit that issue.
What happened with the Sabine County DWI back in 2017 at the same time as this one?
They dropped it.
Okay, at this time I'm going to find that you entered your pleas of true to counts 1 through 6. Find those counts true. Ms. Malfino is exactly right. You're lucky that you made a plea agreement for 4 years, because I'm not really sure that not showing up since 2021 and just saying I want to take my time and be done with it is the kind of attitude that I appreciate. But I'm going to find sufficient evidence at this time to revoke your probation, and at this time revoke your probation, reassess your punishment to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you the trial court certification that shows this was an agreement that I followed, and so you have waived any right to appeal.
All right, buckle in, because this courtroom morning starts calm, but trust me, it does not stay that way. Watch how fast things escalate once probation violations and new charges hit the table.
I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Good morning. Are you Jeremiah Johnson?
Yes, ma'am.
And Mr. Johnson was previously here in cause number 250330, entered a plea of guilty to aggravated robbery, and 250331 also pled guilty to aggravated robbery. Cause number 250408 and 0409 pled guilty to theft of a firearm. The agreement on these were for a 10-year deferred on those 2 aggravated robberies and a 2-year term probated for 5 years on the theft of firearm cases. I've received the pre-sentence report. Has everyone had an opportunity to review these reports? Or the report? Are there any additions or corrections? Not real sure I want to go along with this plea agreement. Mr. Johnson?
I promise that I'll do right this time.
this time?
Yes, ma'am.
You have been in trouble for breaking into people's cars, stealing guns, shooting at people over and over and over again.
Yes, ma'am. God can show me that this is not nothing I want to do in life.
When did he show you that?
Being in jail, incarcerated.
You've been in jail before. You didn't find God when you were there before?
Yes, ma'am. I'm not making no excuses.
Here's the thing. I hope you have.
Yes, ma'am.
I hope that you have found him. The problem is you lose them when you get out of jail.
Yes, ma'am.
And that's what a lot of people do, is when you're looking at time and you're incarcerated, you're like, oh, I don't want to do this. And then you get out and you go start doing the same thing because you think you're cool and you're going to go steal guns and you're going to shoot at people when they... You're lucky you're not here for murder.
Yes, ma'am. I gotta be here for my little girl. I can't mess up no more. I can't afford to.
You're how old?
28.
You're 28.
Yes, ma'am.
You're way older than old enough to know better.
Yes, ma'am.
You know, this is something I see a lot of times with these 15, 16, 17, 18-year-old kids. Your child's 7 years old,
Yes, ma'am.
so it's not like you have a baby and all of a sudden you know you need to be there for her.
Yes, ma'am. I know. I made a few mistakes in my life, but I'm willing to try to...
That's an understatement, don't you think?
Yes, ma'am. I understand.
I appreciate, too, that you're being honest with me today,
Ma'am.
but I have to look out for the community as much as, you know, I kind of have two things I've got to do here, figure out what's best for you, but also what's best for our community.
Yes, ma'am.
Your Honor, I will say when I first met with him that, I mean, early on, he's just said, I'm tired of this life, you know, I don't know why I'm doing this and I need to get my stuff together. And I understand exactly what the court says. Everybody finds God and, I mean, Jesus in jail, you know, but sometimes I think there's some truth that when you're sitting there and it opens your eyes that, you know, you do realize that I'm getting too old for this. I'm just ready to settle down and do what's right. And he seemed to have that attitude when I first talked to him.
Yes, ma'am. I just ask if you give me one chance, just one chance to prove myself.
So I want to make sure, and we're going to go over that. If you get this chance and you violate it,
Yes, ma'am.
you got the rest of your life that I can give you in prison.
Yes, ma'am.
And when I have to spend some time and it bothers me, a lot of times I don't remember. People say, oh yeah, you remember when you put me on probation? I don't. I'll probably remember you.
Yes, ma'am.
Especially because you put things on your face so people can remember you by them. Probably not the smartest thing either, right? Okay. Any reason not to go forward with sentencing, Mr. Smith? All right, so here's what I'm going to do, Mr. Johnson, because of my concerns.
Yes, ma'am.
I'm going to give you an opportunity, but I'm going to hopefully give you some tools to be successful.
Yes, ma'am.
I'm going to find in each of your cases that you enter your pleas of guilty freely and voluntarily.
Yes, ma'am.
And find sufficient evidence to find you guilty. In cause number 250330, defer all proceedings, place you on probation for a period of 10 years.
Yes, ma'am.
You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'm going to go through certain conditions in a few minutes. In cause number 250331, find sufficient evidence to find you guilty. However, I'm going to follow the agreement, defer all proceedings, place you on probation for 10 years. You will pay a $500 fine in that case as well and follow all of the rules and conditions of probation. In cause number 250408, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that, you'll be on probation for 5 years in that case. You're also ordered to pay a $500 fine and to follow all of the rules and conditions of probation.
Quick legal insight: when a defense attorney asks for a professional evaluation, it usually means they're exploring mental health considerations or competency angles. This can majorly affect bond sentencing and even how a case proceeds.
Cause number 250409, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. And you're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. One of the conditions of your probation in each of your cases is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program, so you're not getting out today. But I'm doing this to continue you hopefully making the better decisions. This program is all about making better decisions. Staying away from the people that you need to stay away from. If you really want to change your life, you can. People do it. It's not easy sometimes, but you're going to be given the tools. And if you don't, then you're back here, okay? And so here's something that's very important though. You have a handful of write-ups in our jail.
Yes, ma'am.
I see those. I'm going to see if you have any more between now and when you go to ISF. It will be a violation of your probation if you have more incident reports in our jail, or if you have any in ISF.
Okay.
So if you are disrespectful to those officers that are just out there doing their job, if you're fighting, if you don't button your jumper up because you're too cool to button your jumper up, just follow the rules. When you're out and you're not in custody, you can make whatever decisions you want. When you are in custody, you're going to follow those rules. If you don't, again, that's part of your probation now, is that you follow all of those rules and don't get in trouble. You could be back in here on a motion to revoke your probation before you ever hit the streets again.
Yes, ma'am.
So whatever's going on in the jail, you better go in and say, whoever else is messing around, get on your bunk, do what you're supposed to, get to ISF, get out, do what you say you're going to do, okay?
You said how long, ISF?
It's a 90-day program, okay? So you've got two separate things going here. Now, you've got the deferred probation on those aggravated robberies, which means at this time you don't have a conviction on those cases. That's a great thing for you. It also leaves it open, though. If you violate any condition of your probation, you're back in here. I can convict you of those offenses, and you could be sentenced to anywhere in the range of punishment, which is between 5 years and up to the rest of your life in prison, the whole range of punishment. Also, if you violate on those theft of a firearm cases, you've already agreed in those to the maximum punishment, which is 2 years in the state jail prison. So if you violate, you've already agreed to those 2 years. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Not just any charges, more felony charges. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, you can, or how long that lasts, you can talk to Mr. Parker, all right? Good luck. Take advantage of this opportunity. And Ms. Burge, if you'll please raise your right hand, do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, ma'am.
Thank you. Good morning. Are you Gerson Mendoza? And this is cause number 250304. Will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Mendoza, you're charged with the first-degree felony offense of aggravated robbery from December 1st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you did what they charged you with?
No.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis, with the interpreter?
No.
Yes, ma'am.
And do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, that you're waiving any right to appeal? And it looks like the agreement that you reached is for a 10-year deferred probation, a $1,000 fine, and you would be required to follow all of the rules of probation.
And that wraps Cody's situation, but now comes one of the most dramatic turns of the entire docket. Pay attention when a violent charge meets a reluctant witness, things get complicated fast.
Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
¿Entiendes? Yes, ma'am.
And state tenders number 1?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Mendoza is not competent?
No, Judge.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing so we can get a pre-sentence report done that'll give me more information about you and your case, and then we'll come back later for sentencing. What is the state's position with regard to a bond based on the nature of the...
History is young age, he's 18 years old. This was several classmates that
I can't hear you.
I think he was less than the other defendant. There was a co-defendant in this case.
I'm not going to change the bond based on his age and the nature of the offense. A lot of times what I do in these is possibly ISF or something anyway, just because it had to do with a robbery and a weapon, and he's young. So let's just see what the pre-sentence report says. All right, so you can go back with the bailiff. Good morning. Are you Deontay Wayne? Or Dwayne, Deontay Wayne Reed, I'm sorry. And Mr. Reed was previously in court and cause number 240838, entered a plea of guilty to the state jail felony offense of theft of a firearm. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
State has, Judge. I suspect there's something on page 1 of the court with more accurate, but I have.
Mr. Lewis?
Yes, ma'am, Judge. I've spoken with my client about this as far as his assessment of accountability and for his admission to this offense. At that time, I could tell you, just after speaking with him, he understands the issue with that as far as his making a decision to try to get probation, as he's talked about here in the PSI. That this would involve him not just taking responsibility, but being honest and truthful about his plea, whether he was guilty or not guilty. And of course, at that time, explaining to him that way, he's prepared, of course, to truthfully admit to his involvement in what he did in his offense, which he says he did commit this offense at the time.
So you either did it or you didn't do it. And so if you did it, then you're getting a great opportunity. If you didn't do it, then that's what juries are for, and that's why you would go to trial.
Yes, ma'am.
So did you do it or did you not do it?
I did it.
Okay, and do you want me to go forward with this?
Yes, ma'am.
So what happens is you're gonna be spending some time with probation, and you've got to be honest with them the whole time you're on probation. They're there to help you.
Yes, ma'am.
And so if you try not to take responsibility and try to diminish things that you're having issues with, then you're going to end up right back in here and looking at going to prison. So it's very important that you're open and honest with them. Do you understand?
Yes, ma'am.
Okay. All right, then, any reason not to go forward with sentencing?
Not station.
All right, Mr. Reed, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that. You'll be on probation for $1,000. You will also be ordered to pay
Is that probation for 5 years?
5 years.
What did I say?
For $1,000.
It's been a long morning. Y'all are all like, what is happening to her? Okay. You're going to be on probation for 5 years. You're going to be ordered to pay a $1,000 fine. I was reading faster than my mind was going.
Okay, viewers, this is where every judge gets nervous. When the alleged victim suddenly denies everything the court has to figure out, is she telling the truth, or is she scared, pressured, or protecting someone?
You're ordered to pay $1,500 in restitution also, and to follow all of the rules and conditions of probation. If you do that, this is a good opportunity for you because you're going to be able to serve that 2-year sentence while you're out on probation instead of in state jail prison. The other side of that, though, is if you violate any condition of probation, you'll be right back in here and you'll be looking at that 2-year sentence that you've already agreed to. Do you understand? There's going to be, I want you to get your GED is going to be ordered for you to get your GED. That's to help you so you can get better jobs and do better things. There will be mental health treatment if you need any kind of issue. Everything that they offer you and tell you need to do is ordered, and so you're required to do that, and it's all meant to help you, okay? So you're welcome. And so I'm handing you somewhere the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. Good morning, sir. Are you Desmond Jones? And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Jones, in cause number 250610, you're charged with the state jail felony offense of unauthorized use of a vehicle. That's from March 28th of 2025. And how do you plead to that charge? I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Sentence you in accordance with that agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir.
This moment is huge. Legally competency restored, guilty, plea entered, rights waived. This is where cases shift from uncertainty to outcome question for you. Should someone who is recently incompetent be allowed to plead immediately, or should courts wait longer?
Good morning. Are you Tillia Mills?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Mills, in cause number 240549, you're charged with the state jail felony offense of theft with previous convictions from November 4th of 2023. The indictment alleges you were previously convicted of theft July 14th of 2022 on 2 different cases on that date in Montgomery County, Texas. And then after those were final, you were convicted 2 times on June 21st of 2023 of theft in Harris County, Texas. And how do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State Tenders Number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mills is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft with previous convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am. You can go back with the bailiff.
And now the emotional peak of the entire session, Jeremiah Johnson's sentencing. This isn't just legal, it's personal, raw, and full of tension. The judge is fighting between giving hope and protecting the community.